Good afternoon to one and all. With great sense of pleasure and pride, we at Thomas George and Associates would like to invite and thank Honorable Justice S. Nanda Garu and Honorable Justice M. Sudhir Kumar Garu for joining today to adjudicate the final rounds of today's competition. I now would request the court masters to read out the rules of the competition and then we can start the rounds. Court masters, please explain the rules. Court masters, please explain the rules of the competition to the teams. Shweta and Danvi, please explain the rules to the teams.
Will now proceed to explain the team division granted to each counsel in a single team. Each team is allocated 30 minutes to present their case. Each speaker will be given 15 minutes unless indicated otherwise by the team. Placards indicating time will be shown 3 minutes prior to the lapse of time allocated to a speaker and finally once the time has lapsed. 1 minute each will be allocated for rebuttals and sur-rebuttals.
All the teams, please switch on your cameras. Yes. Now I request the petitioners to start the rounds.
Now both visible and not audible to everyone out here?
Yes, you are audible.
Thank you so much. So a warm good evening, good afternoon to one and all present over here. The council seeks permission to address the bench.
Yes, proceed.
Much obliged. Your Lordship, this is counsel number 1 appearing on behalf of the petitioner in the matter of XYZ versus the Republic of Parliamento. The council seeks permission to collectively address the bench as your Lordships.
Yes.
Much obliged. If your Lordships
Yes.
are well versed with the facts of the case, the council takes permission to summarize the issues for the same to this honorable bench.
Yes.
Much obliged, your ladyship. So the council number 1 would be essentially dealing with the issue of whether or not the government is justified in taxing digital currency, digital assets, non-fungible tokens, which is not legalized yet. And its learned co-counsel would be dealing with the issue of constitutionality of the interim sections in the Income Tax Act. Your Lordship, this issue shall be dealt with by the council in 2 different limbs, wherein the council would first like to acknowledge the necessity of having a regulatory vetting, a censure of a sort first, for any new financial technology to be adopted before the exigency of tax. And the second limb would deal with why there is a need to have a legislation first and taxation next, which are clearly realized throughout the variegates of risks and challenges in regulating the virtual digital assets. Your Lordship, at the outset, the counsel for the petitioners would like to clarify and respectfully submit to the bench that this pleading to quash the impugned section 115 BBH and section 2 clause 47A of the Income Tax Act on the grounds of unconstitutionality, that it is not to be deemed that the people of the Republic of Parliamento are evading or intending to evade such income from being taxed. It is only a modest request on our end, on the council's end, that without any legislative competency for the same, which would act as a catalyst to regulate the mass of volatility of this quantum, would only be ideal enough to be taxed after being governed by a legislation. So there is a need that is realized for a legislation of a sort. So therefore, kindly allow the council to direct the bench's attention to the copious contemplations, plans and actions of the government and the government's aids, which bring about the risk posed by the growing digital transactions and people's interest in them. Because if they are left unwarranted and unsanctioned for, which would lead all the transaction users to succumb to its lucrative interest. So on the first leg, the council would like to throw light on the Garg committee report of 2017. So essentially, Garg committee is a high-level interministerial committee which has been formed to propose specific actions to be taken in relation to virtual currencies, and the mandate of the committee essentially included an examination of the policy and legal framework first for their regulation, to recommend certain appropriate measures to address the concerns regarding the risks and set challenges. The council is permission to share the screen. Just a second. The council will be using
For that,
Dear Lordship.
for that,
Your Lordship.
who is the petitioner here?
Your Lordship.
Who is the
Sorry.
petitioner herein?
The
Who is the
people of the
petitioner?
Republic. The people of the Republic
It's
of
the-
Parliament, Your Lordship.
It's a general public interest litigation. Petitioner
Yeah.
has got individual or it's in public interest.
Your Lordship, sorry for the inconvenience.
Is it in public interest? Is it in public interest this petition is filed, or individual interest?
It is in public interest, Your Lordship. That is why a writ petition under Article 32 has been filed.
But first, this court would want to hear you on maintainability of the writ petition. Before going into the issues, this court would first want to hear you on the maintainability of the writ petition.
Your Lordship, Your Ladyship, under Article 32, when there is no alternate remedy that is to be found in any particular cases, the counsel for the petitioner has approached the honorable bench regarding the same, because when the counsel would like to rely upon the case of F. Garg versus the Union of India, wherein it has been stated that when there is any policy framework with reference to economic fluctuations of the country, the judiciary can step into the legislative platform in order to adjudicate for the same. So since this is about the concerns of economic regulations and economic policies of the Republic of Parliament, the judiciary can step in to entertain this petition. So, and also considering the substantial volumes and jumps in the recent times of pandemic, this digital ledger transactions and virtual digital assets have been taken, it is only ideal for the Honorable Supreme Court to allow and maintain and entertain this petition so as to bring about a framework and deem and to declare and quash that this impugned sections are against the Constitution.
Yes.
If your lordships are satisfied, the council would like to share the screen regarding the compendium for the Garg committee report, the official Garg committee report.
Yes, yes, proceed.
Yes, much obliged. Is the screen visible, your lordship?
Yes.
Yes, your lordship, here is the Garg committee report, which the council has previously stated. The mandate of this report, of this committee, included an examination of policy and legal framework, right? So under the paragraph 1.6.2, which talked about the legal and regulatory risks, it talked about the necessity of a regulatory vetting or of an industrial standards for any new technology to be adopted at a mass scale. So, and also other difficulties have also been outlined over here, wherein it talked about the lack of clarity and ownership and jurisprudence, and even the technological risks have been highlighted over here, which talks about cybersecurity and terrorism, etc. But of course, the elephant in the room, where the legal and regulatory risks are identified by the committee, it is enlightened upon a need for the legislation first before for it to be taxed. And it basically means that when such a volatile and mass scale technology is being adopted by a developing country, only a regulatory framework is felt, the dire need for such standards are felt, and it is identified by this committee that it is still at a developmental stage, and many of the financial sector regulators and standard setting bodies are currently studying the growing ramifications and repercussions of this virtual digital assets, although this has been out and about for almost a decade. So, Your Lordship, it does not just stop here, but rather the lack of clarity about ownership and jurisdiction, customer due diligence were also studied about. All of these, like the council has pointed, have serious ramifications on the general interest of the public if it is left unlitigated or unregulated. So even the committee, which was formed by the government, recommended building appropriate regulation for the development of digital ledger transactions. Here, under the paragraph 1.7, the highlighted portion, the recommendation, it has been stated that the agencies or the arms of the government, such as the RBI, SEBI, IRDA, PFRDA, and IBBI, should also focus on DLT to explore building of appropriate regulation. So, Your Lordship, it has only been stated that legislation, the dire need for legislation is felt because it has been identified the profit. It's a safe haven for almost $43 million, up to a standard of 43, tune of $43 million are being transacted on a day-to-day basis under this platform. So it could be playing a major role in ushering the Republic of Parlamento into a digital age where developed countries such as Canada, Japan, and South Korea, etc., and all the developed countries are actually major players in this field. So, Your Lordship, there are still a few more practical challenges that needs to be resolved, which cannot be answered by the tax regime which has been rolled out, but rather only a legislation would hold the key to unraveling the solution. So the tax provisions are silent about the valuation mechanism to be adopted for computing the fair value of consideration when it comes to the transfer of virtual digital assets. At this conflicts and juncture, Your Lordship, it is only ideal to understand that any value which is being transacted, any amount which is being transacted in this platform doesn't have any government backing nor any commodity backing. It doesn't have value. It is so volatile that at any moment it could lose its value because on a day-to-day basis, even a random stranger could start about his own platform and start trading in this. Either create his own platform and let others transact in the same. So since there is a lack of a commodity or a governmental backup, a legislation which regulates, sanctions, licenses, and authorizes the same could bring about the machinery problems and procedures and deal with this on a very detailed manner, the deliberations of the same. So Council would further like to direct the bench's attention to one of the few practical problems faced by the
Is there one second? Is there any recommendation with regard to taxing in this GAR committee report? Is there anything with regard to taxation, recommendation with regard to taxation in this report of the GAR committee?
Your Lordship, under the GAR committee report, indeed, there is not a recommendation per se, but there has been a point of deliberation where it is stated that, Your Lordship, it is first to be understood that the nature of virtual digital assets is the key to its volatility is obscure anonymity. So where there is no intermediary such as finance sectors or banking, anybody who is anonymous could start transacting in this platform. So in order to identify the source of such transaction, a tax regime is necessary, is what has been deliberated by the GAR committee report, which is 100% agreed by the petitioners. But the thing is, there are other ambits of such ambits of such practical problems which are left unresolved by a tax regime. And for example, an individual with a yearly pay of more than 2.5 lakh rupees who has received any installment on which duty was deducted at tax deducted at source, here it's one person, is required to file income tax return as per the Income Tax Act. So disclosing all the profits. Regardless, there is a confusion among many as to how income from the internet in digital form of money should be disclosed in this case, because of a lack of provision or a lack of legislative backup or a guidance in this regard. It is only realized that there is a need for registration first. So there is no clearance on tax collection also from such profit in this manner. Sorry. Okay. Sorry for the inconvenience, I should have stopped sharing screen. So in the current legal scenario, there is no conviction regarding the tax ailment from the digital money, nor there is any divergence requirement for the pay procured by the income tax department. So Parliament's cryptocurrency bill may require further disclosure. Many countries have already had a cryptocurrency profit tax system in place, although in the case of Internal Mobile Association versus the RBI, where the infamous RBI circular of 2018 was set aside, it is stated that India being Parliament being a developed country should not be left to compare with the other developed countries where the economic boom is much more further. But for the sake of argument or for the sake of persuasive value, it is only ideal to say that it can be the ideas that are put forth in these developed countries could be adopted and modified to set into this economic stature. So arguendo, when a platform which breeds such volatility and anonymity lets the users to obscure identities even further, it would veer towards more criminality is what the petitioners is what the counsel for the petitioner feels. And in the case of Internet Mobile Association versus the RBI, it was observed that if there is a breeding ground for such prohibited activities, such as money laundering and tax evasion, and it is also further nurtured by this volatility, then at least for the sake of having a legal basis to prosecute, to even file a suit in this honorable court or any other platform for that matter, a framework must be brought forth. So the council would like to move on to the second limb of the issue, which talks about the need for the legislation first and taxation next. It is realized throughout the risk of regulating the virtual digital assets. It is humbly submitted that the effort to legalize virtual digital assets may ideally serve to introduce a level of uniformity in understanding and bringing the various government agencies such as RBI and SEBI involved into a same page, while also providing security and preventing its misuse. In the Republic of Parliamento, the virtual digital asset trading platforms are witnessing substantial jumps in volumes by the day, starting from when it grew in volume during the years of pandemic. So if it is properly regulated via a legislation, it can be a win-win situation for both the government and the investors. Because in a developing country like that of Parliamento, the financial literacy lacks its standards. Not many are, everybody succumb to the lucrative interest and many start blindly transacting for the same. And for that sake, it should not be compared with the volatility aspect of stock market, where it also poses the same risk. But over here, the assertion of risk and volatility is placed even at a higher pedestal. So at this juncture, it is pertinent to note that the government had previously proposed schemes to regulate or ban the private functionaries indulging in virtual digital assets, where presently, like at the present moment, the cryptocurrency and regulation of official digital currency bill of 2021 is tabled at the Lok Sabha, and it is awaiting consideration. So this bill, which is placed under the purview of Lok Sabha for consideration, aims to ban all the private cryptocurrencies and create a facilitative framework for creation of official digital currency that is to be issued by RBI. So it is a very appreciable thing that RBI has rolled out a digital rupee for that matter. So when there are possible intendments on the end of the government, which could plausibly lead to a legislative framework, why not just roll it out first and then tax it next, is what the petitioner is trying to put forth, your lordship. So tax could be levied once this bill has been considered. For it addresses this bill in its entirety. It is also attached with the GARG committee report. So if your lordships are at the disposal of the compendium of the petitioner, it could be perused. So for it addresses the lack of clarity and confusion that essentially a tax provision has thus far failed to answer. So for the last limb of the argument, the council would like to direct the bench's attention to the infamous RBI circular of 2018, and which elucidated the public regarding the prohibition of virtual currencies. And of course, this was overturned in the said case. So the council relies upon this case to make its final limb of the argument, to bring about the legislation first and taxes, because the honorable bench observed that the Central Board of Direct Taxes, they had sent a memorandum in the year 2018. So it contained an advice to carry out legislative amendment before taxing him. And this has been observed and acknowledged by the same, also by the honorable bench in the Internet Mobile Association of India case. So it has acknowledged that the non-regulation for the same could amount to tax evasion, and due to growing lucrative opportunities, this niche platform could go unwarranted for. So at this juncture, the council would finally like to point out that under the Moot proposition paragraph 3, it has been stated that the Republic of Parlamento is a member of international organization, which is akin to the United Nations organization. So what is the draft, the policy, final policy regulation of the United Nations say regarding the stature of cryptocurrencies? The council, it has been thoroughly perused, and it has been stated that the United Nations is they are not in favor of legalizing cryptocurrencies in developing countries. But if the developing countries are trading in it in such a substantial volume, there is a need to regulate and legalize it first before proceeding further. Also, the it is only ideal to point out that the United Nations has also mentioned regarding the tax scheme, where it has been stated that a tax regime could only help a developing country in curbing tax evasions or the likes. So when United Nations and all these contemplations on the end of the government signal a prospective legislation could be brought forth, when all the plannings such as these are regulated, why not bring forth it first and then accrue for tax regime, which could be beneficial to both the parties, to both the government and the investors. Therefore, Your Lordship, it is humbly contended by the petitioners that though the income earned from virtual digital assets do fall under the bracket of taxation, irrespective of its non-legality of the same, it is only wise to bring about a legislation to regulate this transaction, then tax it owing to its deepening perplexity. Your Lordship, it was an honor arguing in front of this honorable bench. If there are any questions the Lordship would like to ask.
Yes. Your argument is mostly on the ground that in the absence of law, the section 115 BBH of income tax cannot be implemented in its true spirit. It appears in that direction mostly.
Indeed, Your Lordship.
There is nothing to that. The provision is unconstitutional, but your contention appears to be that absence of law, the income tax authorities may not have proper mechanism to assess the tax or assess the income.
Indeed,
there is nothing to show that it is unconstitutional otherwise.
Your Lordship, in order to satisfy your claims regarding the said question, the learned co-counsel would be dealing with the constitutionality aspect of the impugned section, especially section 115 BBH. But since your Lordship has requested, under Article 265 of the Constitution, it states that only under the authority of law can an income be taxed. So it essentially talks about two set of the unconstitutionality of a set provision could only be challenged. The constitutionality could only be challenged when there is a breach or a teeth in fundamental rights, or when there is a lack of legislative competency. And the latter in this case is what is being infringed upon and contended by the petitioners. But in this particular case also there is a breach in the doctrine of intelligible differentia. The co-counsel would handle it better, Your Lordship, in order to satisfy your claim.
Okay.
It was an honor argue in front of this honorable bench, Your Lordship and leadership. The council would now like to recuse and over to the co-counsel. Much obliged.
Yes.
Am I both audible and visible?
Yes.
Yes.
May it please this honorable court, this is counsel 2 on behalf of the petitioners in the present case XYZ versus Republic of Parlamento. Counsel 2 appears on behalf of the petitioner. Counsel seeks permission to address this bench collectively as Your Lordships.
Yes, your counsel who spoke just earlier, she pointed out that section 115 BBH of Income Tax Act is violative of the Constitution of India. How do you explain, and can you cite any judgments of the apex court
Indeed, Your Lordship. Council 2 will be dealing with the second issue, which is whether or not Section 115 BBH of the Income Tax Act is violative of the Constitution. It is humbly submitted before this Honorable Supreme Court that Section 115 BBH of the Income Tax is violative of the Constitution because, firstly, the government has no legislative competency to levy tax upon the VDA, and secondly, the impact whatever given upon by the Supreme Court by setting aside the ban of VDA in the Internet of Mobile Association versus RTI case. So the first leg of the issue is regarding the lack of legislative competency to levy tax upon the VDA. So the Republic of Parliament, though, did not enact any law to legalize the framework of digital assets, digital currencies, NFTs, and so there is a need to draw a distinction between the lack of legislative competency of a state to make and enact a law on a particular topic covered by any of the lists in the 7th schedule and its incompetence to make a law abridging or abolishing the rights or in violation of any other provisions of the Constitution. As there is lack of legislative competency, the law will be made void. So by the reason of Article 265, every tax has to be imposed by law. It would appear to follow that it could only be imposed by a law which is valid by conformity to the criteria laid down in the relevant articles of the Constitution. These are the laws should be within the legislative competency of the legislature being covered by the legislative entries in Schedule 7 of the Constitution. Secondly, the law should not prohibited by any particular provision of the Constitution. Article 265 of the Constitution.
You mean to say, please wait. You mean to say that the Parliament acts in 115 BB
Council begs your pardon, Your Lordship.
You mean to say that Parliament lacks competency to make? No, you mean to say that Parliament lacks Section 115 BBH. You followed?
Indeed, Your Lordship. The Council contends that as the legal position of the VDA has been decided, so it lacks the legislative competency to impose the tax upon it.
No, in order to verify whether the Parliament has legislative competency or not, what are the parameters to be looked to?
Your Lordship,
is it included in this one? Is it included in the list 1? This item of income tax, direct taxes is included in list 1?
It was mentioned in there are list under list 82. It was mentioned income on other than agricultural income, and it was also mentioned income from the capital assets. But the petition
that falls within the purview of a Parliament. The list 1 items falls within the purview of the Parliament.
Indeed, Your Lordship. The list 1 items fall within the purview of the for Parliament. But here the petitioners are contending that as the position of the VDA is not decided properly or as it is unclear, so the legislature doesn't have the legislative competency to impose the tax upon it, is what the petitioners are contending, Your Lordship.
Yes.
Indeed, Your Lordship. In the present case, the legislature has no authority to impose the tax on the VDA because the Republic of Parliament, though, did not enact any law regarding the legal position of the VDA. In the Pesi Kaka case, it was observed that a declaration of unconstitutionality brought about by lack of legislative power stands on different footing from a declaration of unconstitutionality brought about by the reason of abridgment of fundamental rights. Both this declaration of unconstitutionality go to the main root, that is the legislative power, that is the legislative competency. And in the case of National Provincial Bank versus Ainsworth, the court noted that the cryptocurrencies are not a legal tender in the sense of being a regulated currency issued by the government, but do have the fundamental characteristic of intangible property as it being a thing of a value. So due to the improper legal position in the country, it led to the law being arbitrary in the nature, Your Lordship. So it is well settled that a law which is beyond the power of the enacting body is not a law at all, and such a law cannot acquire the validity by the mere passage of the time. And the same was held in the case of Canadian Federation of Agriculture versus Attorney General for the Quebec, Your Lordship. And the power of the statutory authority to do something has to be tested normally with reference to the persons or entities or whom the power is exercised. The question to be addressed in such cases is whether the authority had the power to do that act or issue such a directive, the person to whom it is addressed. So when the validity of an enactment is called into the question, the first thing for the court to do is to examine whether the act is a law with respect to the topic assigned to the particular legislature which enacted it. The scope of Income Tax Act is to provide the taxability of any transaction, and which also includes illegal transactions. Although VDA does not make them legal just because they have been taxed under IT Act. So there is no clarity regarding the head of the income also under the income from the transfer of VDA, which has been classified. So it is further submitted that the tax rate is irrespective of the nature of the income. Income can be business, capital gain, or other sources. Government is not clear on what nature of income it wants to tax. In such a scenario, it is creating a wide scope for the government to impose the tax upon the transfer of such assets, as there is no intelligible differential and a lack of clarity over such taxation. This would hugely impact all kinds of players unreasonably. Therefore, such a policy should be set aside. It is further submitted that the tax will not be deducted on expenses nor set off against losses. The losses cannot be carried forward for the next financial year as well. All these stringent measures, which will not only discourage players to leave the market, but also force certain players to invest in VDA underground to evade the tax also, Your Lordship. So it is respectfully submitted that this taxation policy is highly discouraging citizens to invest in the VDAs, as this taxation policy is not guaranteeing the legality of the trade of the VDAs, and profits out of such trade are taken by the government without any regulation on its part, Your Lordship. While discussing the part to impose tax on the income other than the agricultural income, the legislature through section 115 BBH of the income tax didn't direct the income arising from the transfer will fall under which specified head, that is either on capital asset or from the any other, Your Lordship. Coming to the second leg of the argument, impact of Supreme Court setting aside the ban of VDA in the case of Internet and Mobile Association of India versus RBA, the judgment is clear that the petitioner succeeded and the circular issued by the RBA is declared to be unenforceable. Due to this judgment, the business can rejoin the industry and hence can trade in VDA. However, it is important to know that the Supreme Court in its judgment have only struck down the circular issued by the RBA, but haven't declared the virtual currencies as legal or illegal. Moreover, since there is no legislation regarding the same, therefore, virtual currencies remain unregulated in India. And in the case of state of Kerala versus Haji K. Kutinaha, it was observed that where objects, persons, or transactions essentially dissimilar or treated by the imposition of a uniform tax, discrimination may result, for in our view, refusal to make a racial classification may result for in the view, which results in denial of the equality. If the lordships are satisfied with the arguments put forward, the council was required to move on with the prayer.
Yes, granted.
Prayer. Wherefore, in the light of facts stated, arguments advanced, and authorities cited, it is most humbly prayed and implored before the Honorable Supreme Court of Parliament, though, that it may be graciously pleased to adjudge, declare, and quash that the government is not justified in taxing digital currencies, digital assets, NFTs, which are not yet legalized. And secondly, the section 115 BBH of the income tax is violative of the Constitution. Also, pass any order that the Honorable Supreme Court may deem fit in the favor of the petitioner to meet the ends of the equity, justice, and good conscience. For this act of kindness, the petitioner shall duly bound forever pay.
Yes.
The council would like to retire, Your Lordship.
Yes. Any rebuttal? Any reply?
Please, this Honorable Court, this is Counsel number 1 appearing on behalf of the respondent in the present case. With the permissions of of the bench, this counsel would like to address the bench collectively as Your Lordships.
Yes.
Your Lordships, if you are well satisfied with the facts at hand, the counsel would proceed with the issues in the present case. Before moving on to the issue, the counsel would like to take a couple of minutes to explain the maintainability of the present petition in this regard. It is contended that the petitions are not maintainable under Article 32, mainly because under Article 32, the major requirement is that there should be a violation of a fundamental right to approach this Honorable Court. However, in this present case, there is no violation of fundamental rights per se. It is a well-settled position of law that the mere imposition of a strict tax is not violative of the fundamental rights enshrined under Part 3 of the Constitution. In this regard, the council will be stating the case of Federation of Hotel and Restaurant Association of India versus the Union of India, where the court held that a taxing statute is not per se a restriction of the freedom under Article 19(1)(g) of the Constitution. The policy of a tax in its effectuation might, of course, bring in some hardships in some individual cases, but that is inevitable. The mere excessiveness of a tax or even the circumstances that its imposition might tend towards the diminution of earnings does not per se constitute violation of Article 19(1)(g). Therefore, the instant petitions are not maintainable before this Honorable Court. Your Lordships, this council will be dealing with the first issue, which relates to whether or not the government was justified in taxing these digital currencies, digital assets, and NFTs, which have not yet been legalized per se. So it is a well-settled position of law that the Parliament has the power to impose tax upon any income, irrespective of its legality, Your Lordships. To this aspect, there are various Supreme Court judgments. The council will be relying on few of them. So in the case of CIT versus Thangamani, the court held that the income tax authorities are not concerned about the manner or means of acquiring the income. The income might have been earned illegally or by resorting to unlawful means. Illegality tainted with the earning has no bearing on its taxability. And similarly, in the case of CIT versus SC Kothari, it was held that it is well settled in common law that even if a trade is illegal, it is still a trade within the meaning of the Income Tax Act, and its income, profits, and gains are chargeable with income tax. The main object behind the enactment of the Income Tax Act itself was it was an act to levy, administer, collect, and recover income taxes in India. Moreover, with respect to the arguments raised by my learned opponents with regard to the legislative competency and the power of the Parliament to impose taxation, it is to be noted that the Parliament has full competency to pass the particular section 115 BBH in light of the powers conferred under it under Article 248 of the Constitution, which are to be read with entry 82 and entry 97 of List 1 of the Constitution, Your Lordships. Article 248 basically grants residual powers to the legislature, and entry 82 of List 1 pertains to taxes on income other than agricultural income, and entry 97 deals with any other matter which have not yet been enumerated in List 2 or List 3, including any tax not mentioned in either of those lists, Your Lordship. Moreover, with regard to one of the contentions raised by my learned opponents, they wanted to draw an analogy between the position of other countries and the position with respect to the Republic of Parliament. It is to be noted that in some of the developed countries which my learned opponents stated, such as Tokyo, such as US, and such as Canada, it is noted that in these countries as well, cryptocurrencies have been recognized and they have been taxed accordingly, Your Lordship. In the case of Tokyo and US, they have been recognized as property, and in the case of Canada, they have been recognized as an commodity, and they have been taxed. And in case of Tokyo, a high taxation of up to 58% have been imposed by the government in that particular case, Your Lordship. Moreover, my learned opponents relied on the GARP committee report of 2017. The erstwhile committee actually submitted its report in 2019, and due to the judgment of the Internet Mobile Association case, the committee's recommendations could not be fulfilled, Your Lordship. Thereafter, the government's position has drastically changed, and even in that particular committee report, the need for regulation was rightly discussed. However, it is argued that the government is in the process of bringing out a regulatory framework, and that is the reason for the initial taxation, which will eventually lead to a regulation, Your Lordship.
How do you justify the action of the government in taxing digital currency?
Your Lordship, digital currency is a very new concept, and the market is quite volatile, Your Lordship. And with regard to India, with regard to Parliament, it is a growing economy, and the economic policies of the country deem it necessary to tax these so as to avoid any form of hardship to the citizens per se also, Your Lordship. It is to be noted that under the facts, it has been stated that this present section 115 BBH has been implemented as an interim term, Your Lordship. It is not mentioned that it is a final legislation which is to stay forever.
Yes.
You mean to say that it's a temporary legislation?
Indeed, Your Lordship, as per the wordings of the facts. So if your Lordships are at the perusal of the facts, I would like to state...
Can there be a temporary legislation and permanent legislation as such?
Indeed, not your lordship. What the council is trying to reiterate that the government is in the process of bringing out a regulatory framework, but for the time being, to reduce the hardships and mainly with regard to the AML, the CFT norms.
Hardship of whom? Whose hardship?
No, sir. Hardship. The lot of risks are to be faced with regard to the transactions in cryptocurrencies, your lordship, and these risks are to be faced by citizens of the country, your lordship.
No, that may require regulation, but not taxing.
Indeed, your lordship, the government is merely imposing a tax so as to derive on the income which is being derived out of such transactions, your lordship. The government does not imply anything in this particular instance.
No, you said it's a temporary.
Indeed, your lordship, as per the facts. So if we
Where
look at,
from you get that it is temporary?
no, lordship, as per the
says so.
facts of this particular moot proposition.
Yes.
If we refer to paragraph number 5 of the moot proposition, it is stated that the Republic of Parlamento did not enact any law to legalize the framework. An attempt to ban these form of digital currency or assets was set aside by the Honorable Supreme Court of the Republic of Parlamento. While the government continues to contemplate its stance on cryptocurrencies and NFTs, it has in the interim implemented a new tax regime aimed at taxing gains and or income from virtual digital assets at 30%, your lordship.
Yes.
Your lordship, this was with regard to the first issue. If your lordships are satisfied, the council will rest and my co-counsel will proceed with the other issue with regards to constitutionality. It was an honor arguing before this honorable court. Thank you, your lordships.
Council seeks permission to address the forum, my lordships.
Yes.
My lordship, I am council number 2 for the respondent, and I will be dealing with the constitutional validity of section 115 BBH. This council vehemently contends that section 115 BBH is not violating of constitution on 2 grounds: that it possesses the legislative competence and that it does not violate any of the fundamental rights enshrined in the constitution. First, this council will be dealing with legislative competence. As the co-counsel already mentioned, this tax is within the legislative competence of the parliament. Section 115 BBH has been enacted by invoking its residuary powers under Article 248 to be read with entry 82 and 97 in list 1 in 7th schedule. Reading of Article 248 with entry 97 in the list 1 in schedule 7 makes it clear that the constitution makers took care to ensure that the parliament had the sole authority to enact laws with regard to any issues that up until the date of constitution had not been perceived for legislation or had by chance been left off of list 2 or list 3. The case of VDS falls within this ambit. This means that the only thing, if the legislative competence is questioned, to be looked into is whether the imposition of tax or the entry, whether it falls in entry of entries in any list 2 or list 3 of the constitution. If it does not fall, the parliament has the ultimate power to legislate on that entry. Once the legislature has the power to once the legislature has the competency to legislate, the motive with which tax is imposed is immaterial. This is regard to the legislative competence of taxation. The council will be moving to the second sub-issue, that it does not violate any of the fundamental rights enshrined in the constitution. It is also contended that the section is not violative of any of the constitutional and fundamental rights enshrined in the constitution. The legislature had made a clear demarcation between VDAs and other kinds of asset classes. It is clear by a definition, a separate definition under section 2 clause 47A in the Income Tax Act is provided. Further, a timely clarification by CBDT via clarifications and notifications has been provided at various instances. My learned co-counsel seems to attack the validity of constitution only based on the grounds of regulation, and the power to taxation has not been clearly dealt to, your lordships. On the other note, the section 115 BBH is again not constitutionally invalid on the ground of violating the freedom of trade and expression. As my co-counsel already mentioned, a higher tax regime or a tax rate per se cannot be a restriction in freedom to trade. It may be high but inevitable. again, the power to legislate on taxation is within the economic wisdom of the legislature, and there cannot be no question on it. The judiciary cannot question the economic policies and the power to legislate, power of the parliament to legislate on taxation policies. Once the legislative competency satisfies the rate of taxation, the quantum of taxation, the subject matter lies with the legislature, Your Lordship.
Yes, what are the Indian legislations which have a direct bearing on the legal aspects relating to illegal virtual currencies?
Your Lordship.
What are the Indian legislations which have a direct bearing on the legal aspects relating to illegal virtual currencies?
There is no regulation per se on virtual digital assets, Your Lordships. What this government is taxing only the income of the
Are you able to hear?
Lordship, I think he's just lost his connection. Just a couple of minutes, Your Lordship.
Yes, try to restore it.
Your Lordship, am I visible and audible?
Now it is audible.
Sorry, Your Lordship. Sorry for the technical inconvenience, Your Lordship. With regard to regulation on PDA's respect to illegal virtual digital assets, there is no regulation per se, Your Lordship. We have only taxed the income on transfer of virtual digital assets, and we contend that it has its legal competence to tax. And when the legal competence is satisfied, the rate of taxation and other consideration lies with the legislature, Your Lordship.
Yes. Yes. You proceed with
Yes,
your
Lordship.
submissions. Yes, you proceed with your submissions.
Hence, it is contended that the legislature possesses the legislative competence and does not violate any of the fundamental rights enshrined in the Constitution, Your Lordship. If Your Lordship is satisfied with the arguments, I seek a permission to move the prayer.
Yes.
Wherefore, in the light of the facts presented, issues raised, arguments advanced, and authorities cited, the respondents humbly pray that the Honorable Supreme Court of Parliament find the arguments meritorious and dismiss the writ petitions by the petitioners.
Any reply to the respondents' contentions by the petitioners?
Indeed, Your Lordship.
Yes.
Just a second, Your Lordship. Sorry for the inconvenience there. For better, sorry. Your Lordship, these are the questions that the counsel for the petitioners would like to put forth to the learned counsel for the respondents. The first question would be the learned address to the learned counsel for the respondent. So the learned counsel for the respondent mentioned that the Parliament's power to levy tax is a legislative competence. It is legislative competence. So where is the power derived from regarding the taxation of income from virtual digital assets, considering there is no legislation for competence in the first place? So if the counsel would like to move to the second question. So how does the learned counsel for the respondent seek to clarify the breach in the doctrine of intelligible differentia with respect to income from virtual digital assets, based on which income slabs are assigned as per capital gains and business gains?
Your Lordships, am I permitted to answer to these questions?
Yes.
Your Lordship, the first, with regard to the first question, by a mere reading of the provision section 115 BBH, under the first subclause, it is stated that where the total income of an assessee includes any income from the transfer of any virtual digital asset. So therefore, the main aim and motive of taxing virtual digital currencies is merely based on the income that is derived out of such transfer, Your Lordship. And the Parliament, through the Income Tax Authority, has all the legislative competence and the power to tax any form of income, Your Lordship. This is a well-settled position of law, and the same has been initiated by the Council for the Respondents in through various case laws as well before this Honorable High Court.
Yes.
With regard to the second issue, I think my co-counsel will be answering it.
Sorry, beg your pardon, Lordship. Can the second question be repeated? There's a technical issue from this side.
So, Your Lordship, if it pleases this honorable court, learned opponent counsel, how does the respondent seek to clarify the breach in the doctrine of intelligible differentia with respect to the income from virtual digital assets, based on which income slabs are assigned as per capital gains or business gains?
With respect to income from VDS, it differs in individual circumstances. If it's an individual gain, it comes under capital gains. If it has been taken as a trading asset where the business has been conducted over the period of time, it comes under the profit from business or other profit from business and profession. So the point of the argument of Article 14 seems to be quite vague also. Am I audible?
Yes. Yes, anything further on either side?
Put forth by the
Anything for counsel on either side to add?
The Council for the Respondent rests its case, Your Lordship.
Yes. What about petitioner?
Likewise, Your Lordship, the counsel for the petitioner rests their case.
Yes.
Respondent counsel to answer this. Is it not correct to state that 30% crypto tax along with lack of set-off provision for losses kill the industry?
Your Lordship, this is with the economic policy regarding taxation lies with the legislative competence, Your Lordship. Even if it causes hardship and equity are not considered a taxation policy, Your Lordship. And further disturbance by the judiciary will lead to the judicial overreach of its power, Your Lordship. This solely lies with the quantum of taxation, the rate of taxation lies with the competence of the legislature, Your Lordship.
Yes.
Thank you, Lordship.
You mean to say that this quantum of taxation doesn't fall within the realm of judicial review?
No, Lordship. What is contained is that it comes under the economic policy, and this is a kind of an economic policy which comes under the legislative competence, Your Lordship. The rate of taxation and quantum of taxation cannot be questioned, Your Lordship.
Yes.
If your lordship and your ladyship has no further questions to the participating teams, we request your lordship and ladyship to give a feedback of the session to the participants. And after the feedback, your lordship, we will take a short break of 15 to 20 minutes before starting the valedictory session and declaration of results, your lordship and your ladyship.
Yes. All the counsels have argued well. But then in actual court proceedings, there are no questions posed by counsel to a counsel. It is only the court which poses the questions. Are you able to hear?
Indeed, Your Lordship. Indeed, Your Lordship.
Yes.
The concept of rejoinder is well grasped.
Yes. In court proceedings, it is only the court which poses the questions. There is no
Indeed.
question of a counsel to a counsel.
You can
But then
pose questions to yourself.
all of you did well. Wish you all the best.
Thank you,
Thank
Ladyship.
you, Your Lord. Thank you.
It was an honor arguing before your lordships.
Yes.
No, one thing, I think both Nandaji and myself have started practice at a time. And when we started our practice, we never had courage to talk like this. You are doing very well, and wish you all the best.
Thank you, Your Lordship.
Thank you, your lordship.